have to sue them, right? And that's where attorneys like me you just love it, right? We love people that don't have integrity and don't follow the terms of their
That's your bread and butter.
So
So let's get into the fact of, you know, we want to write these agreements up, right? And we want to buy a lot of these kind of notes, right? How can do we have to work with an attorney that's licensed in that state, or can we work with attorneys such as yourself to draft the general documents in purchasing this kind of asset in the escrow instructions?
that is a great question. I mean, most attorneys are licensed as attorneys in their respective states, right? So I'm a Texas licensed attorney. One of my business partners, he's a Texas and Georgia licensed attorney. So for me, I can draft documents in Texas, right? Could I, in theory, draft a general document? Yes, but the concern for attorneys is that what passes in Texas may not pass in California, and that could be considered malpractice. So, you know, as capable as I think I am, even in other states, I would tell somebody, hey, look, if you're going to go buy a note in California, use a California attorney. If you're going to go to Nebraska, use a Nebraska attorney, because I can tell you there are a lot of attorneys that come to Texas and try to draft these sort of general documents in Texas. And I look at them and go, geez, I mean, what on earth? And it's not even close, because Texas is extremely strict. And Texas is one of the more complex states legally. That's why our bar exam is one of the most difficult in the country, because the laws are complex here. So you need to, as an attorney, you need to make sure you're not committing malpractice. So if you can't, anybody that's on this call, I can do what you need in Texas, but you would be best suited getting an attorney outside of Texas for whatever state, wherever. If the collateral is in Nebraska, then you probably want a Nebraska attorney to go look at it. If you're hypothecating,
you say, is there a way to find attorneys like yourself? Is there a category that we should be looking up?
Is there a network?
You know, I've been asked that before, and to my knowledge, there is not. There's no database that I've ever found. There's no resource that I'm aware of as an attorney that would allow any group of individuals to go find attorneys in other states. And I've not only been asked in this context, I've been asked in the creative financing context. I mean, it's like every week. I mean, every week I'm getting a phone call. Hey, geez, Sean, you're great in Texas, but can you do something in Florida for me? No, I can't draft a deed for you in Florida. Well, do you know anybody? No, I sure don't, right? Because it's such a hyper specific sphere. The note sales, the hypothecations, creative financing, sub-twos, wraps, right? I mean, and every law is different. I mean, Texas, it's more difficult to do a wrap transaction and a subject to transaction than it is in Arizona. I mean, Arizona, it's easy, right? And here, got a few additional laws you got to follow. So unfortunately,
similar to like Texas, you know, land contracts are no in Texas, right? And a lot of the subject twos and the wrap notes that are created have come across as land contracts and CFDs. That's just an example of Texas law that you can't create land contracts in protection of everything. When we talk about this stuff, do you recommend someone to get a basic understanding of notes, the legal, a consultation with someone like yourself? What is the first step to someone who says, I want to buy a hypothecation or sell one, and can I draft it? And would you represent both parties if both parties wanted to use you?
Great questions as part of that. The first suggestion I always give to anybody is, you know, go find an expert in your field. Like I mean, I know, for example, that you know, USA Home Partners, Nick is one of the ones we deal with. He does a heck of a lot of business in Texas, right? He's a great resource. So if you're going to do something in Texas, go find somebody that's done the note sales. Go find the investor that does it. I mean, you guys, New Jersey, I don't know anybody in New Jersey. I know you're an expert there.
Yep.
Right? So go find somebody like yourself that's a resource to go ask the question. Let them be your mentor. The second thing I would say was, to your point, you got to have an attorney that knows what they're doing in this sphere, right? Because I cannot stress enough how bad a poorly drafted note or a poorly drafted assignment could impact the validity, could impact the sale. Monetarily, it's a big deal, right? I mean, if somebody drafts a note and it's not considered a negotiable instrument in Texas and it's considered a non-negotiable note in Texas, you can just rest assured the value of that note's going to drop by an exponential amount, right? So the second piece of the advice I would give is to find an attorney that you can go have a quick consultation with. Yes, it might cost you a few $100, but I'll tell you what, it's worth the $300, $400, $500 that you may pay now, because you're going to save that later, getting sued for $15,000 because you signed a full recourse note and you had no idea what that was, right? Or a non-recourse. So that was my second suggestion, would be to partner up with an attorney. And then the third is, frankly, you just got to jump in at some time. And it's to be part of groups like this. Listen to podcasts like this, right? You guys do a great job of talking to people and help educating, and it's just at some point in time, then you just dive right in.
Yeah, and my experience is that most things are fixable. If there's some kind of like the note wasn't written correctly or something like that, or for example, this is years ago, but I bought land contracts in Texas and then just converted them over to a deed of trust. So it's fixable. It's not necessarily easy. It's not necessarily cheap, but you can do it.
You can fix. I've always said you can fix just about anything.
Yeah.
But to your point, Nathan, how much does that fixing cost you, right? Yeah. So if you spend $500 on the front end to make sure it's done right, then you might save yourself $50,000 on the back end. Even though it's fixable, it's just some people I think are afraid to put up money at first, and that is a bit terrifying. But to me, it's worth it, especially in this area.
Yeah.
Some people were asking for your contact information. In the chat, we have a link to just fill out. It's a form on our website. You'll get Sean information regarding his partner in Georgia. Just fill the form out and he'll reach out to you and follow up with any kind of questions you got. When we buy these kind of hypothecations, and another softball question, buy 1 year, can I go buy a second year? Another $6,000 next come around? Can I keep doing it on the same note?
Can you keep buying partials, or can you keep loaning out, keep hypothecating, loaning out?
Yeah, on the same note. Can I hypothecate once and do it again and again?
Yeah.
Right. So some people are saying, well, if I do $6,000 now, I'm done. No, you can do as many times as you want, right? But we really focus on the fact that this hypothecation versus this no partials, it depends on what kind of person you are and what you're looking for. And then make sure you have the attorney in place to review the collateral as well as review the document that you're signing regarding the transaction. Both items need to be reviewed, because if something happens, you make sure you're backed up. And understand what a partial is in regarding to the schedule, if the buyer pays off or whatnot. Where hypothecation, if the borrower pays off the original debt, you may still have the hypothecation going. Because if your agreement doesn't say anything about it, they may just keep borrowing your money for X period of time.
Yeah, I mean, and I think to your point, David, is part of the thought process has to be, what am I doing this for? Right? Mm-hmm. Am I doing it to scale my business and go buy more notes? At what point do I stop buying notes? At what point do I stop collateralizing against notes? Am I collateralizing against my performing notes so I can go buy 10 more notes, right? So what's your future plan? So I would encourage any newer investor, even seasoned investor, come up with a 1-year plan, a 3-year plan, and a 5-year plan on what you want this business to be, because that's going to dictate whether you sell notes or hypothecate notes, right? I mean, that's how you, and generally both of them can allow you to scale your business. But you got to have an idea of where you're going in order to make decisions now.
We had one question regarding what happened if the borrower gets foreclosed on with the seller and didn't tell you about it. Is there any way to get notice that the foreclosure is happening?
Well, that's a good question, loaded question. In that, if I'm in the partial note world, and there's an assignment of interest, even if it's 10%, if there's an assignment of interest in the note in the deed of trust, well, then now I have an ownership of that note. So the foreclosure notice, in theory, I should be put on notice that it's going to be foreclosed. The hypothecation, since nothing's filed of record, that's a little bit more problematic.
And do you recommend doing hypothecation on wrap notes versus partials, or selling a wrap note because of the issue of the original borrower with the power of attorney situation. We're feeling that a hypothecation is probably a better suited thing because you don't want to transfer that note over and then have to deal with the original subject to owner kind of thing.
Yeah, I don't know. I mean, to me, there's really no difference legally, in my opinion, as to what may happen. I mean, I suppose they're it kind of is, but like I said at the start, it's a numbers game, in my opinion, right? It's how much do you want now, right? What is your business going to be like? How much would the note be sold for versus how much can you get as a loan from the investor on your performing asset. So to me, I think you got to decide numbers first. Then, because again, if you have a good attorney, either one of them can be structured in a way that you're protected. So I think you have to decide first from a numbers standpoint, what decision you want to make, and then go from there.
So this question was, why is negotiability important? I think it's the fact of figuring out what you as a buyer or you as a seller want in the note, in the deal, to be noticed of, and make sure you cover everything. It's easy to say cover everything. You don't know what everything is. But as Nathan and I started with a note space, we didn't know what a launch was.
Yeah.
And you kind of learn, you make some mistakes, and you ask your attorney, is there anything I'm missing in this protection process? And they're going to do the best to protect you, but there's no foolproof plan that things just come up. People file BK and change ownerships and all kinds of stuff. But yes, so when we do this kind of stuff,
I was going to, sorry to interrupt, David. I was wondering,
Yeah.
wondering if that question for you, they meant negotiability as in negotiating on the note sale, or if they meant negotiability as in the legal sense, is it a negotiable note or a non-negotiable note?
Stephen, if you can comment back on there, I'll watch the feed for it. If there's any question about that. But yeah, so I want to make sure people understand when we're buying and selling notes, we're not going to buy at what we call par. Steve said legal sense. So yeah, that's always negotiable. Whatever agreement me and Nathan have is what we agree on.
Yeah.
Yeah. And I think Stephen, I think it was his name. I mean, in Texas, so in the legal sense, that is a pretty big deal under the section 3.201 of the Texas Business and Commerce Code. In order for it to be considered a negotiable instrument, it's got to be money to be paid to the payor. It's got to be payable for a certain amount of time, and there can't be any other act or undertaking outside the payment of the money. Right. So if you don't satisfy the Texas Business and Commerce Code, then it's not considered a negotiable instrument. If it's not a negotiable instrument, then it's considered a non-negotiable note. A non-negotiable note is then subject to common law rules versus statutory law, right? So when you're in the non-negotiable note world, the prices of those notes are significantly less. In my personal opinion, I wouldn't be purchasing non-negotiable notes, not really ever. So, but that was a really good question, Stephen.
So is that would that be like a HELOC?
No, I mean, that's probably still, that's still negotiable. It would be, I'll give you an example of what a non-negotiable note would be. You've got the promise to pay, right? You've got the borrower, you got the lender. And then in the note term, you have it as no term at all, right? So there's no 30 years, there's no 10 years, there's no 5 years, there's no balloon payment,
Gotcha.
right?
Okay.
There's no maturity date. It's just this indefinite period of time. That would be considered a non-negotiable note. I'll give you another example.
It's not a good day.
If you want another one. I've seen some investors put in these notes for, they put in these notes on like rehab loans and things like that. Well, they'll put in the note, they'll say, it's going on payoff, you got the interest rate, you've got, whatever the maturity date. And then they say in the maturity date, owner to all or borrower to assign interest in its LLC in connection with this note as part of its payment, right? Like I'm going to acquire an equitable interest in an LLC as the lender. So that's an act. That's an act outside of the promise of money. So that would arguably make that note non-negotiable. So these are concepts that are really boring, but for me, they're fun, which is why you need an attorney to look at them.
So a couple quick things here. I want to remind everyone, it'd be side comment real quick. The DME recording